Okay, hello everyone and welcome to today's lecture. My name is Uzma and I will be taking today's lecture. So this lecture is the HSC Revision Legal Studies lecture, and it is brought to you proudly by ATAR Notes. So as most of you would already be aware, ATAR Notes provide high school resources to essentially allow students all the success. So I'll go through some of the resources before we get into today's lecture that you can take advantage of as you now approach the HC sort of area and you're now getting into prepping for the HSC. So these are some of our free resources that we offer, starting off with our hundreds of downloadable study notes. So if you have certain topics or certain areas that you're a little bit confused with, this is a great place to go and download some of those notes and have them ready. Lectures, which you're watching one right now, but there are many others, so please ensure that you do have the opportunity to register to all the other lectures as well that you may be interested in for your subjects, etc., for skills, tips and tricks, etc. We've then got discussions, so online Q&As, things like that, because I know at this point you'd probably have a few questions for certain things that you're revising, so that's a great place to get those questions answered. We've then got videos, so a lot of engaging online revision to break away from your traditional textbooks and black and white notes as well. We've then got newsletters to help all of you stay in the loop. ATAR calculator, if you have a certain ATAR in mind, how much do you need to get to that ATAR? So just to see if you're on track. We've then got articles with lots of study strategies and tips and heaps more. So if you are interested in any of these resources, please do visit the link down here, atarnotes.com/register, to access them. And we've got some more resources which are our paid resources, which are all created by elite students to help you get the best marks possible. So we've got TuteSmart, which is online tutoring from elite recent Year 12 graduates. So essentially, if you are interested, they're all recorded, so it's not like you missed out on a year's worth of stuff if you register now. And we've got we're now in the stage of like revision classes, getting all the questions answered that you need. So if that's something that interests you for a particular subject, we've got that available for you. It has plenty of resources and plenty of recordings for you to watch back on as well. Study guides, which is printed revision materials with top tips to help you get great marks. So I'm sure many of you would have seen our study guides. They are the colourful ones that are quite thin compared to the textbook, so it's a lot easier for students to process information compared to the textbook, which has a lot of information. And Ed Unlimited, which is essentially your study guides all in one place online. So if you're somebody that likes to have access to all of that online for convenience, then definitely have a look at Ed Unlimited. So if you're interested in those as well, it's the same website, so atarnotes.com/register. So yeah, those are our resources. Moving into today's lecture. So today's lecture is revision for legal studies. So what is the agenda? Today we'll be going through human rights, and then we'll also go through how to smash the HSC and skills to allow you to do that. Okay, so today we will not be focusing on crime, but I do have some important tips and advice that we'll go through before we move on to the human rights component. So first of all is to revise the themes and challenges and the principal focus. So this is really important for all aspects of the legal studies syllabus, but especially for crime as well. So themes and challenges. So these are directly from your syllabus, and so is the principal focus. So principal focus is through the use of a range of contemporary examples, students investigate criminal law, processes and institutions, as well as the tension between community interests and individual rights and freedoms. There's a lot to unpack there. Contemporary examples, we know we're looking at the LCMID there, so legislation, cases, media, international instruments and documents. We've then got investigate criminal law, the processes, the criminal investigation process, the trial process, all of that, as well as different institutions. And then we're looking at the tensions between community interests, so what's best for the community versus individual rights and freedoms. This is both the rights of and the freedoms of the victim and the offender and the community and society, which we often look at the balance between all of those, which we'll go through in a second when we look at themes and challenges. So that is the principal focus. Often students skim over this, but it's essentially a really good summary of exactly what you're learning about. So are you able to really unpack this, and are you able to essentially say that you know all of this in enough detail is the question. Themes and challenges, the role of discretion in the criminal justice system. So the role of discretion throughout all the topics, try and figure out ways in which we can see discretion. So for example, in police powers, we can see discretion. Where do we see discretion in the court system, in the judicial system, etc.? Issues of compliance and non-compliance in regard to criminal law. So where can we see these issues arise? What do we think of the effectiveness of that? Extent to which the law reflects moral and ethical standards. This was actually the question that is quite often posed, right? And we can see that this question is quite important because moral and ethical standards is something that legal studies really tends to highlight and tends to want to address. The role of law reform in the criminal justice system as well. So what is law reform? It's changes in the law. Why do we have changes in the law? How have they occurred? Do we have examples of them? Extent to which the law balances the rights of victims, offenders, and society, just like we looked at over here with community interests and individual rights and freedoms. Individual is victims and offenders. Community is essentially similar to society. Finally, effectiveness of legal and non-legal measures in achieving justice. What are our legal measures? Anything like legislation, common law, all of those. Non-legal measures, protests. We have many organizations that aim to address things in that way. Media as well. So a lot of different sources and measures that you can have a look at there. So essentially, those are our themes and challenges that are incorporated all throughout the syllabus, all throughout the crime syllabus. So have a look at some examples, list the examples for each one, create a separate Word document or separate page in your notes and look at each one, make a list or brainstorm or draw diagrams, whatever works for you, but just try to have enough for each one, because the legal studies, people that make the exam could literally just pull one of these and have that as your essay. Next up is to revise the student learn tos. So really, really important. It's also known as the right-hand side of the syllabus, which I'll show you. So this is, for example, from the criminal trial process. We have the right-hand side of the syllabus. Describe the role of the courts in the criminal justice process. Right, you go through the court jurisdiction, the adversary system. You then look at, discuss the use of the adversary system as a means of achieving justice. So you learn about the adversary system first, and then you apply it. How does it help achieve justice? What does it do? What are its characteristics as well? Examine the role of legal representation in the criminal trial. So you go through the legal representation in the left-hand side, and then you apply it on the right-hand side. So after you go through a revision of this, see if you can answer these. And if you can, you're on the right track. If you can't, and there's a certain area you're confused with, please try and address it. Talk to a teacher, talk to a tutor, talk to somebody who can help you out in trying to understand them. Because again, they can pull, the people making the paper can definitely pull questions from here. Assess the use of defences to criminal charges in achieving justice. Evaluate the effectiveness of the jury system in the criminal trial. Right, so you learn about the juries, the role of juries, including verdicts, and then assess the effectiveness of the criminal trial process as a means of achieving justice. This is literally an essay question that you can practice. Right, so really, really important. So it's literally, these smaller questions are helping you build up to answer this question as well. Next up is to make essay plans. So practicing writing a whole essay can be quite daunting, and you will have done it. I would highly recommend that you do it and that you're comfortable with it. When you get comfortable with it and you're like closer to the HSC time period, you don't want to be spending like, you know, a whole hour or a whole 45 minutes or however long it takes you to write an essay. You don't want to be spending that much time just writing an essay, and this goes across the board for crime and for your options as well. Rather than doing that, write essay plans. So, okay, bullet point, you've got a question, bullet point, what would you write? For example, it's this question. Okay, bullet point, what would I write in my intro? What would I write in my body paragraphs? What would I write in my conclusion? Rather than writing a whole essay. And then also bullet point what cases you would use, what media you would use, how you would link that, all of that. Do not spend too long on the crime essay. You want to make sure you have enough time to look back at your work as well. Remember that your options are actually 50% of your entire exam. They literally are 50 out of 100 marks. Your crime essay is only 15, right? So weigh up the comparison. Don't take as long as you would take in your options in your crime essay, right? Try to reduce the time you spent on your crime essay compared to your options because they are worth more marks. Yeah, and that concludes sort of information I wanted to just run through quickly with regards to crime. So now we'll move on to the main idea that I wanted to have a look at, which is human rights. So we've got the human rights, nature and development. So definition of human rights. So first of all, important to just note that human rights are the basic entitlements that everyone possesses. So simply by being human, you are entitled to these rights. So human rights have 4 characteristics. First of all, they are universal, which means that they are the same for all people. It doesn't matter of your age, of your gender, your sex, your religion. Essentially, it doesn't matter. Inherent, so birthright of all human beings, right? So it's essentially as soon as you're born, you inherit these rights. Inalienable, basically this idea is that they can't be given up or sold, right? You can't sell these rights, you can't give up these rights. And indivisible, meaning that all rights are equally important. So the government doesn't really give you these rights as you already have them. It is the responsibility of the state or the government to recognize them. So human rights can evolve over time. So this essentially just means that they change when community values and community ethics change, when standards change, because we're an ever-evolving society. So these rights can evolve. So let's move on to the abolition of slavery. So slavery, what does it refer to? It's basically a person being completely under the control of another person and considered to be their legal property. So there's no basic human rights, and we can already see that these are not being achieved, right? So there has been a push, or a significant push for reform regarding the issue, and as a consequence, most countries have abolished slavery between 1833 and 1865, right? So essentially it's not as common as it was, but in saying that, there is definitely still issues with regards to this. Australia was slow to respond as they only abolished slavery in 1980. So a very big jump from the dates here to 1980. In response to slavery, international formal statements were developed, such as the Universal Declaration of Human Rights. So the UDHR, which I'm sure most of you would have already heard of. Please do take note of this if you don't already have it in your notes. It's a very important declaration, and it's very important for this topic. However, as it is a soft law, the International Covenant on Civil and Political Rights was enforced in 1976. So this is simply known as the ICCPR. So soft law, we don't really it's not really as enforceable, whereas hard law is legally enforceable, just to clear that up. So as the ICCPR, when it was essentially became legally enforceable in Australia, Australia became a signatory to the treaty and enacted it into domestic criminal laws, which means that it becomes a hard law. And this was done in order to prevent slavery and punish it as well if anyone was caught committing that act. So the main law in Australia to prosecute individuals who use slaves for forced labour and sex slavery is the Commonwealth Criminal Code of 1995, which again is highlighted in yellow. So all of the important declarations, legislations are highlighted in yellow, and then all of the cases I've highlighted in purple as well, just for your benefit. So please do note these down if you don't already have them in your notes, because they're very important. So the first successful prosecution for slavery, and I'm sure many of you have heard of this case because it's the most commonly used case for this section of the syllabus, was the R.V. Wei Tang case of 2008, where she received 10 years of imprisonment on 5 counts of sex slavery after trafficking from Thailand. Right, so essentially it's one of those cases of recent day or modern day slavery, where a lot of people have this misconception actually that slavery doesn't exist. It definitely does. So further amendments to this law was seen in the Slavery-like Conditions and People Trafficking Act as well, 2013 Commonwealth. So this Commonwealth just means like essentially this idea that it applies across the country, federal compared to NSW. So that essentially concludes the slavery aspect of the syllabus. We'll now move on to the second one, which is trade unionism and labour rights. So trade unions, what are they? They're referred to as a collective group of workers formed to protect the rights of workers of a particular industry or occupation. So initially it was illegal to be a trade union member, and thus employers had greater bargaining power over employees. So it's quite it is quite a negative thing that, you know, it was illegal to be a trade union member, because a lot of the times this just meant that employers were able to exploit them. Trade unions then sort of emerged from the 1850s Industrial Revolution in response to appalling conditions and lack of safety, low wages, long hours, things like that. So essentially it was not great for those who were working during that time. So to protect union rights internationally, trade union rights are contained also in the UDHR. And I'm sure many of you may have known that the Australian Labor Party has a lot of roots coming from trade unions and fighting for labour rights. And it's the current party in power, so there you go. There's a little bit of a history lesson, I guess. However, it is a soft law, the International Covenant of Economic, Social and Cultural Rights, was basically implemented and introduced human rights such as the right to form and join trade unions. So first prosecution regarding this law in Australia was seen in the R.V. Trivedi case, where he was sentenced to 250 hours of community service and fined $1,000 for abusing an employee from India. So you can see that the difference between soft law and when it becomes hard law, how it changes, because then it becomes legally enforceable. Whereas soft law, even if it's broken, there's really not much that you can do. So yeah, however, the small penalty highlights that it's a lack of deterrence for despite that non-compliance with the law. Today, trade union membership has declined due to the increased use of enterprise agreements, so agreements made at the workplace level in a bid to increase productivity. So we don't see as much trade union membership nowadays. Okay, moving on to universal suffrage. So universal suffrage refers to the right of all people to vote as a part of a democracy. So initially voting was only limited to wealthy men and yet extended to all males in 1983 and federally to women in 1902, where South Australia was the first state to grant the right to vote in 1894. So you can see that there is a little bit of a change in that. So essentially, it wasn't always the case that everyone could vote, and the main people were people that weren't wealthy, women in general, and the Aboriginal Torres Strait Islander people as well. Some Indigenous people were not granted the right to vote until 1962, with Western Australia and Northern Territory granting this right in 1967. So internationally, the right to vote is contained again in the UDHR as well. However, as it is a soft law, the ICCPR was implemented and introduced human rights, such as the right to participate in public affairs as well. So in Australia, the right to vote is recognised as an express right in the Constitution, so it is within our Constitution, which cannot be changed unless there is a referendum. However, issues regarding the right to vote arose from the case of the RV Electoral Commission 2007, where prisoners sentenced to more than 3 years imprisonment in Australia can't vote. So there are still issues to be addressed in terms of little areas and aspects that still need to be considered. Next up, we've got universal education. So universal education is the right of all to basic education, specifically primary education, regardless of age, sex, ethnicity, or race. There has been a push for universal education, and it didn't begin until around the 19th century, in which primary education in Australia became compulsory in 1970. So internationally, the right to education is contained in the UDHR and the UN Convention on the Rights of the Child. So essentially states that education in primary school should be compulsory for all children. However, as the UDHR, again, it's a soft law. It was enforced and implemented as well. In Australia, the right to a universal education was enforced through statute law, so legislation. What's that legislation? It's called the Education Act of 1990 Commonwealth, where primary education is compulsory for all individuals under the age of 17. So, despite this effective response, literacy rates amongst Aboriginal and Torres Strait Islander individuals remains low, especially in remote communities. So there is still a gap in the system to ensure that we can get the literacy rates up for everybody in Australia, including the Aboriginal and Torres Strait Islander people. Next up, we have self-determination. This refers to the right of people to have and determine their own political status and to choose how they will be governed without the influence of any other country or state. So the right to self-determination is a collective right. So it is upheld by a group of people rather than individual people. First concept of self-determination evolved from the United Nations Charter of 1945, which states that the purpose of the UN is to develop friendly relations based on equal rights and self-determination of all people. So this right to self-determination is contained in the Universal Declaration of Human Rights 1948, the ICCPR and the ICESCR as well. So all Australians have the right to self-determination of our own political affairs and free and fair elections as well. So recent issues that have arisen include the self-determination specifically in relation to the Aboriginal and Torres Strait Islander individuals deciding their own future within a country. So, despite the overturning of the legal fiction of terra nullius, Aboriginal and Torres Strait Islander individuals are still seeking self-determination to control their traditional land and health, etc. And we know that in the news, you may have heard of the vote for the Aboriginal voice, which is definitely something you can discuss in your responses if it comes up. Next up is environmental rights. Environmental rights are the right of people and future generations to enjoy the same level of environmental quality, providing a clean and safe environment, right? So essentially sustainability, having access to resources now and in the future. So there has been no universal recognition and acceptance of environmental rights. However, we have had many international treaties that have aimed to address this issue, many of which you may have heard of. So 1977, we had the Kyoto Protocol, which was developed in Australia, which Australia became a signatory to rather in 2007, and it ratified into our domestic laws, so it's enforceable now. However, as this treaty came to an end in 2020, essentially the Paris Climate Agreement was held in 2015 and basically developed the Paris Agreement of 2015. So this proved effective as 195 countries adopted the first universal and legally binding global climate deal, which aims to reduce global temperatures by 2 degrees Celsius. So that is a big deal because, although it's a small step, it can make a huge difference. However, the human rights breach is seen through the displacement of people due to global warming and have become environmental refugees. And we know we've heard of earthquakes and floods, and every few months we hear something, bushfires, etc., wildfires. So there's always something going on, and unfortunately, that is something that must be addressed because it's getting worse by the minute. So environmental migrants aren't covered by the 1951 Geneva Convention relating to the status of refugees, as that specific one is only really designed to protect people that are fleeing persecution of war or violence, not really environmental issues. So therefore it is a necessity to add climate change refugees to international law to protect their rights as well. We then have peace rights. So peace rights are the fundamental entitlements afforded to all people to live free from conflict, from war, and any form of oppression. So the right to peace is a collective right, again, similar to self-determination, and was a fundamental aim of the United Charter. However, in situations that may threaten regional and global peace, the United Nations Security Council is authorized to act under the authorization powers as well. So if a state commences an illegal war, it is considered an act of aggression, and parties concerned can be tried in the ICC, or the International Criminal Court, in an attempt to restore world peace, because we know that state sovereignty exists, so this is done also to combat state sovereignty. Human rights have continually existed through the ages, evident through ancient laws, writing, and inscriptions. So we're looking at here the UDHR 1948. So following the events of World War I and World War II, the Universal Declaration of Human Rights 1948 was adopted in response to the mass atrocities, allowing for a wider recognition of a wider range of human rights. So the UDHR 1948 didn't explicitly define what human rights and fundamental freedoms were, making its enforceability quite difficult, in addition to being a soft law. So really it was quite difficult because, first of all, there wasn't many definitions. Second of all, it's soft law. It's not enforceable. It's not ratified, so you can't really do much. Despite the declaration not being legally binding, the document carries more moral weight. So essentially, you're probably going to be shamed by other countries if you decide to go against it. So due to lack of enforceability, it has led to the development of twin covenants, which we've talked about before, the ICCPR and the ICESCR. Both of these conventions are hard law, meaning that they are legally binding and come into force upon the ratification of certain number of states. So the ICCPR is a multilateral treaty that aims to protect as it's in the name, the civil and political rights, so helping individuals against arbitrary use of power, etc. This is evident through human rights protected in this treaty, so right to fair trial, right to freedom of thought, conscience and religion, rather. Then we've got the ICCPR 1966. As Australia has become a signatory to this treaty, we have implemented domestic laws to punish those who breach these human rights. Right, so compliance of the ICCPR is monitored by the HRC, or the Human Rights Committee. Essentially, they publish a report on each country every 5 years to see where they're sitting, and they have the power to hear complaints brought by, against each other, so one country to another country, or individuals against their country as well. So what are some cases that are relevant? So Toonen v Australia, and Blessington and Elliott v Australia as well. So those are two cases that you can definitely have a look into if you do not have enough cases for this section. We've then got the ICESCR 1966. Is a multilateral treaty that aims to protect all economic, social and cultural rights. So as Australia has become a signatory to this treaty, we have implemented domestic laws to punish those who breach human rights. So for example, the right to education, equal rights for men and women, etc. Whereas it's under the Committee on Economic, Social and Cultural Rights. They don't really hear individual petitions, unlike the previous one, the ICCPR. And then we've got Australia criticised by a committee that we don't have a Charter of Rights, which we'll talk more about as we progress. Moving on, again, we've got the case that we talked about earlier of R.V. Trivedi. And so essentially, this is something you may have heard of, this idea that the UDHR 1948, the ICCPR, and the ICESCR all make up the International Bill of Rights. So if you hear this term, you now know what it consists of, right? And you can be asked that, definitely. Next up, we have human rights, promoting and enforcing internationally. So, state sovereignty. So a state is an independent country, so it's defined by territory, permanent population, effective government, and state must be recognised by other states. And all of this, for example, Australia has been able to achieve. They're an independent country, yes. They're defined territory, yes. Permanent population, yes. They have an effective government, and it's recognised by other countries or states. So state sovereignty is the power to make your own decisions without external interference, right? So essentially, if Australia decides that they want to include a voice for Aboriginal and Torres Strait Islander peoples in Parliament, then, I guess America can't come and say to Australia, no, you can't do that, because they are an external interference. This is something that's related to the country. It's a country federal matter, then it stays within Australia. However, it creates major issues when human rights breaches occur. So, fundamental principle of international law is that no nation state can interfere in the domestic affairs of another nation unless authorized by the UN. And the UN will really only authorize this in some cases, for example, R2P of 2005. So where they have a responsibility to protect. So if there's a war or innocent civilians are dying or they feel like the country is in ruins, then they can step in to help protect or to help the people. The UN weakness in enforcing its decision on human rights due to state sovereignty is a lot of the time related to vetoing. So the United Nations Security Council and other members of the council have the right to veto certain decisions as well, which can be a huge area of ineffectiveness in the system. You've then got arguments for and against state sovereignty. So arguments for state sovereignty is that states can exercise influence in international forums. They can impose sanctions on other states for breaches of human rights as well. and they can implement domestic laws protecting human rights without really any interference from other countries. And against is that you can ignore international human rights as a country. States enact discriminatory laws and engage in repressive practices because they know no other country can come and say anything. States can remove existing domestic human rights protections that they have in place because, again, they know that no one can come and say anything. And states can ignore domestic human rights violation as well. So if there's countries where, there's violations of these rights, then states can simply ignore them because they can say, oh, well, it's not really in our sovereignty. So the United Nations is the world's largest IGO and is the chief organization involved in international law. So it was established via the United Nations Charter of 1945. So they have a General Assembly where the Parliament of Nations with 193 members, each member has one vote. And all members have equal voting power on international discussions, declarations, and recommendations. So here's the Security Council I was talking about. So they are responsible for international peace. They have 15 members and 5 permanent members. So US, UK, France, Russia, and China are the 5 permanent members, and the 10 others, which are just members, are elected for 2-year terms. So not all members are equal. All right, so permanent members have the power to veto that I was talking about earlier. So the Charter gives it the primary responsibility for international peace and security. So they have a very important role. Power to send peacekeepers as well, and can impose economic sanctions and military action as well. Then we've got the International Court of Justice. So this is a judicial arm of the UN. They settle legal disputes between nations, and they give advice on matters of international law if they need it. They don't have to comply with the rulings handed out because of state sovereignty, though. So really it's just advice, or it's just recommendations that can happen. But, at the end of the day, they don't really have to. The country doesn't have to follow anything. So East China Sea dispute between China and Japan is an example of that. Then we've got the Bill of Rights. So when we're looking at, then we've got arguments for and arguments against. So when we've got the United Nations, we know that the International Bill of Rights, for example, has promoted human rights. So that's an argument for. We know that the ICCPR and the ICESCR are binding and enforceable. So committees will check for compliance. Then we know that the UN Summit has also brought the responsibility to protect, which is often, very useful. Or it's a really good concept on paper, but it has been useful, but not to the extent that I'm sure many people would have liked. 2011, UNSC voted to act against Libya, so enforced mainly by the US, but no decision to take action, for example, against Syria. So there's definitely areas of ineffectiveness that need to be addressed. Environmental rights have risen internationally. Arguments against, though, like countries like China still believe human rights don't exist, so up to individual states to decide on the rights of their people. The UN inability to handle international conflict as well, because, again, state sovereignty exists, and that there has been criticism that the permanent 5 of the UNSC all have nuclear weapons, and they've created this exclusive nuclear club whose powers are unchecked. And a lot of people have also complained. So these are all basic ideas that people have said are against it. And people believe that these are true. So another one is that they are very Eurocentric. So IGOs, the UN obviously is the biggest IGO with 193 members. So United Nations Human Rights Council, IGO within the United Nations is made up of 47 states, and it's elected by the UN General Assembly. They're there to protect human rights globally and promote them, addresses situations of human rights violations, and then they make recommendations as necessary. So Australia is a member, and countries are critical of Australia's election due to inhumane treatment of refugees, the Aboriginal Torres Strait Islander incarceration as well, homelessness, terrorism laws, which breach civil liberties. So essentially, a lot of people were unhappy that Australia was a member. But in saying that, many other countries, including the Permanent Five, all have areas where people can criticize them as well and have been criticizing them. So, yeah, something to note there. African Union has attempted to address the prevalence of child soldiers in Africa. An Arab League has suspended, for example, Syria's membership. We've then got the International Court of Justice, which is the relevant court, where they are a judicial arm of the UN, so they're a court underneath the UN. Settle legal disputes amongst member nations, like the example that we gave on the East China Sea dispute. We've then got the International Criminal Court, so the permanent court with jurisdiction to prosecute individuals who commit crimes against the international community. So jurisdiction includes anything like genocide, crimes against humanity, war crimes, and crimes of aggression are all examples of crimes that can be prosecuted under the ICC, or the International Criminal Court. So this was created by the Rome Statute in 1998 and enforced in 2002. The situation is referred to by the UNSC. Alleged crime occurred in the territory of a member state and accused is a signatory member of the ICC. So Syria has not ratified the Rome Statute and can't arrest President Assad only if UNSC agrees, for example. So cost is relatively expensive. So as the ICC's annual budget is 100 million Great British pounds. So lack of enforcement of arrest warrants, and not all countries have signed on to the Rome Statute. We do have a relevant case here, which is the prosecutor v. Lubanga case. So basically found guilty in 2012 conscripting child soldiers in Congo, which is a war crime. So he was sentenced to 14 years in prison, and the Forbes 2014 wrote an article essentially saying 12 years, 1 billion for 2 convictions, $1 billion. So they're saying, well, is it really efficient if you're spending 12 years and $1 billion for 2 convictions? So whilst the ICC is successful in protecting human rights, international courts are time-consuming and need resources to secure a conviction. And that's an example of a media article. So like this is an example of media that you can incorporate into your essay as well. Not essay, sorry, your short answer responses as well. Next up, tribunals. So before the ICC was established, the tribunals prosecuted individuals responsible for crimes during specific conflicts, so ad hoc. Right, so first of all, we have the International Criminal Tribunal for Rwanda. So this is specific for the Rwandan conflict. So it tried essentially those that were responsible for genocide and the violation of humanitarian law. So estimated that 100,000 to 1 million Tutsis and moderate Hutus were killed from April to July of 1994. So they had another case which resulted in life imprisonment. And then we also had the one for the former Yugoslavia, so a tribunal for the former Yugoslavia, which was established by the UNSC in 1993 through Resolution 827. So essentially has jurisdiction over breaches of the Geneva Conventions and essentially the butcher of Bosnia, where Mladic was given a life sentence. So no one escapes impunity, it's a rule of the law, right? No one is above the law. Ad hoc, temporary, slow processes, delays, costs are argued by those that basically have said that these are certain criticisms of these. Looking at independent statutory authorities, we can look at the Human Rights Committee. So they monitor compliance of countries fulfilling the ICCPR 1966, and every 5 years they write a report as well, and they hear complaints brought to one country against another and individuals as well. The Committee on Economic, Social and Cultural Rights, we know that they also monitor compliance following, obviously, the ICESCR. They hear complaints brought to one country against another. They don't really hear individual petitions, but Australia has been criticised by the committee that we do not have a Charter of Rights, and the treatment of homeless 100,000 Australians on any one night are homeless. So this, again, is something of a criticism of Australia. Then we've got non-government organisations. So these are organisations that work independently from the government, so not with the government. So they act as agencies of reform, and they apply moral pressures for governments to uphold human rights and to do something about it. So they raise awareness through media campaigns, so they're promoting, not enforcing, because they don't have the power to enforce, but they do have the power to promote. So for example, Amnesty International exposes violations of human rights all across the world. And Anti-Slavery International and Anti-Slavery Australia are examples as well of NGOs. Then we've got media. So media influence public opinion and law reform and promote government action. So they investigate and report on contemporary human rights issues. The media is a vehicle, an agency for change or promotion of change. So it is a non-legal response that can only expose the issue, cannot legislate or enforce. So really important to note that. So Human Rights Watch produces detailed reports about human rights abuses. So compared to Daily Telegraph, which is more sensational news, etc. Okay, moving on to human rights promoting and enforcing in Australia. Okay, so human rights in domestic law. So no single document in Australia where all human rights are contained. So we don't have one specific document like how the US has a Bill of Rights. We don't really have a Charter of Rights here. So human rights are protected from a variety of different sources. So this can be international treaties or constitutions, common law or statute law. So Australia has a dualist system where Australia has signed a human rights treaty. It's not self-executing and it doesn't become part of Australian law and is not legally binding. Simply signing a treaty and ratifying it doesn't make it enforceable under Australian law. So important to note that. So human rights in domestic law. So our parliament in Australia has to pass laws that reflect the content of the treaty. So sign, ratify, enact. In France, once the treaty is ratified, the country formally approves it as legally binding, and then it's sort of an act of parliament. So that's a monist system. So for example, the International Covenant on the Elimination of All Forms of Racial Discrimination was the first human rights treaty adopted by the UN. So this act was further incorporated into the Racial Discrimination Act of 1975, Commonwealth, and the Anti-Discrimination Act of 1977, NSW. Then we've got the division of powers. So this is essentially how the powers are divided between federal and state governments. So exclusive powers include the Commonwealth making laws such as external affairs, currency, marriage, defence. Right, so these are exclusive powers that are given to the Commonwealth government. Then we have residual powers which are given to state governments, so crime and justice, local government, etc. And then we've got concurrent. So concurrent is where Commonwealth and state can both make laws, so health and education. So the Constitution has granted the federal government exclusive power to legislate in regard to external affairs, so Section 51, which gives the Australian Commonwealth authority basically to enter international treaties. Then we've got the issue of marriage. So federal government is responsible for legislating laws on marriage. So the High Court unanimously voted that the Marriage Equality Act were inconsistent with the Federal Marriage Act and therefore were unconstitutional. So Commonwealth v ACT 2013, which went to the High Court. So as a result, as of December 2017, we have the Marriage Amendment Act, and this was the amendment to the Federal Marriage Act, so law reform. Separation of powers. So this essentially prevents one group or person from gaining total power and ensuring that the rule of law is protected. So the government is separated between the executive, legislature, and the judiciary. Executive is looking at essentially the government. It's looking at Governor General, the ministry, the government departments, the people who enforce the law, so police. We then look at legislature, so they're looking at elected lawmakers in parliament, so people that are making those legislations, and judiciary, so these are the courts who interpret and apply the law. So there's a legal notion underpinning separation of powers, which is the rule of law. So there is no arm of government above the law, essentially is what it's saying. No one is above the law, and there's a division or separation, of these powers for a reason, so that they don't all combine together and have unlimited power. So what's the effectiveness? We've got legislature and executive, cabinet maybe in both. Some laws have been introduced which erodes the separation of power. And so these are basically areas of ineffectiveness rather. So amendments to the Crimes Act 1900 in 2011, for example, R.V. Jacobs 2013, the defendant received life for murdering a police officer. So express rights, these are rights that are clearly and expressly written in the Constitution. So for example, the right to vote under Section 24, the right to acquisition of property on just terms under Section 51, the right to court review of government decisions, so immigration for example, under Section 75, the right to trial by jury of serious federal offences under Section 80, the right to freedom of religion under Section 116, and the right to no discrimination based on your state under Section 117 under the Constitution. So the express rights are expressly stated. Implied rights are not expressly stated, but they are implied, essentially, just like the name suggests. This is the High Courts interpreting the legislation. So they basically use this power through cases to recognise rights that haven't been explicitly stated in the Constitution. So for example, the freedom of speech and the right to legal representation. So we have the case of Dietrich versus the Queen of 1992, which recognised the importance of a fair trial through the provision of an implied right to legal aid to the accused in a serious criminal trial. Great, so effectiveness, rights are protected by the Constitution. They can't be taken away by Parliament. Only a referendum can change the Constitution. So the High Court is able to find implied rights in the Constitution using modern interpretation. However, a limited number of rights in the Constitution. So most people don't read the Constitution and are therefore unaware of their constitutional rights, which is actually an argument for the Charter of Rights, which is just like one document with all of your rights in there. Statute law. So statute law is law passed by the Parliament, obviously. It's a main way in which human rights are promoted in Australia. They reflect community values and set standards in the enforcement of human rights. So it can be international law, so you sign, ratify, and act. And again, we've got the Convention of Eliminations of All Forms of Racism and Racial Discrimination Act, as well as the Crime Legislation Act as well. All right, so the effectiveness of statute law. So statute laws can be passed to make our international obligations part of the domestic law, as well as reflect community values. So if Australia feels that their rights are being taken away by statute law, the government can be voted out. So we have those rights in that way. Statute laws aren't always fixed because they can be removed by acts of parliament. So mandatory sentencing and terrorism laws have a negative effect on human rights in NSW. So reduced the discretion of judges and magistrates to make a decision, and contrary to the rule of law and separation of powers, and infringes civil liberties. So we've got areas to consider there on both ends of the spectrum as well. Then moving on to common law. So common law is judge-made law that is based on the decisions of previous judges in higher courts. So judges protect our own rights when hearing case by case and setting a precedent. So the precedent is then binding on all lower courts. So for example, Dietrich versus the Queen, again, went through this case as well. So what is the effectiveness of this? Judges aren't elected and are less likely to cave into public pressure. The idea is the High Court is able to interpret the Constitution to find implied rights, which is always good. Common law is not that effective. There is areas of ineffectiveness. The Parliament can always pass a statute that is different to the right granted under common law. Statute law does override common law in those cases, and courts have to follow in general it does override common law, and courts have to follow precedents. So current decisions are consistent with previous cases as well. Then we've got the courts and tribunals. So Australian Human Rights Commission, which is federal, monitors human rights issues. So they examine laws to check whether they fit with human rights standards. So inquiries into, for example, the actions of federal government bodies and institutions to see if they have denied human rights but can only conciliate a solution. The idea is that the main role promotes public awareness about the human rights through ad campaigns. So Human Rights Commission investigates, conciliates, and then recommends. So if not resolved, they can complain and take the matter to the federal court or the federal circuit court as well. What is the effectiveness of this? We know that the Human Rights Commission actually does a lot to promote human rights. They refer the matters to federal courts. However, if there is no criminal conviction, it's solely an apology. So that's, an area that needs to be improved. The Australian Human Rights Commission is able to hold inquiries, and the Australian Human Rights Commission enforcement powers are weak, so decisions and advice aren't always legally binding. So that is a bit of an issue that needs to be addressed. The AHRC doesn't have the power to investigate state-level cases, only federal. Alright, so that's something to note as well. So High Court of Australia. The High Court has the power to set precedents on other courts and can overturn state or Commonwealth legislation and develop common law. So essentially they can declare state and or Commonwealth legislation to be inconsistent or invalid. Right, and so to uphold rights listed in the Constitution, that we have the case or the example of Dietrich versus the Queen again, which had the implied right to legal aid and to ensure a fair trial. So you can see how that plays a role clearly. Then we've got non-governmental organisations that we went through earlier as well. So they promote, again, not enforce human rights. They're important as an agency of law reform and awareness of breaches of human rights. So through media articles, through organisations that sort of highlight or allow us an understanding of what's going on. They influence public opinion, and then that public opinion will ultimately promote government action if necessary. However, a non-legal response only exposes the issues. They don't really enforce or legislate them unless the government decides to do that. So it can be all for nothing. Australian NGOs focus on single areas of human rights because they are not large enough to convey all of the human rights issues. So, for example, anti-slavery Australia simply works to abolish all forms of slavery, which is a very big concept, but again, not like they're not looking at everything in human rights, they're looking at that specifically. Media is used as a vehicle. So media is used as a vehicle to influence a human rights issue. So they can promote law reform and act as an agency as well. So they can influence public opinion as well by releasing articles that highlight certain issues in the system, and promote action from government in that way. So Australian reports such as the ABC or SBS play an important role in reporting human rights domestically and globally as well. However, media ownership in Australia is very concentrated to only a few owners, so that can play a role as well. So this idea of the same breaking news culture, only the most shocking news is reported in a sensationalized way. Then we've got the Charter of Rights. So a Charter of Rights is a document which sets out the basic rights to which every human should be entitled to, that we've talked about before. Within Australia, the extent to which human rights would be protected would depend upon the way in which a Charter of Rights was created. So legislative Charter of Rights is this idea that it could be legislated as a part of statute law or constitution. If it's a legislated Charter of Rights, it is created by Parliament, right? So effect this has on the protection of human rights is at the will of the Parliament. So human rights can be changed over time, as we know. Constitutional Charter of Rights, so effects on human rights would be protected very differently. So this type of charter to some extent offers a better level of protection as it's difficult to change once it's there. To change this charter, the state would need to have a referendum, like we are having one soon for the yes or no vote for the voice. So it's time consuming, it's costly, and in this case may not always be successful in terms of having that constitutional Charter of Rights. So we've got those arguments for and or against. So for a Charter of Rights is this idea of failure of existing law. So human rights are scattered throughout statutes, the common law and constitution. So just allow one place, everything's there. So improvement of international reputation. So the UN Human Rights Council recommends that we have one. So we can sort of say, hey, look, we listened to your recommendation. Australia is the only Western democracy without a Charter of Rights as well. And then arguments against, 64% say that the existing human rights protection are adequate. A Charter of Rights doesn't necessarily ensure human rights are better protected. It's just a list of the rights, essentially, is what other people are saying. So, for example, Zimbabwe has one and that hasn't stopped human rights abuses. And making a list of rights could limit our rights to whatever is on the list as well. Alrighty, so that concludes the content component of today's lecture. I hope that that was insightful and you learnt something new and you were able to absorb that information. I know it was a lot of information, but now we are going to move on to smashing HSC and the skills side of today's lecture. So let's get into that. Alright, so then we've got what does your HSC exam look like? So most of you would already be aware of this because you would have done your trial exams and you would have sort of an idea of what it will look like. But regardless, I thought I would put it up here just as a sort of summary or of exactly what's going to be in your exam. So we first of all have 20 multiple choice where 15 are coming from the crime section and 5 of them are from the human rights section. So just making sure that you're practicing those, and they're a very easy section to practice because it doesn't take as long as writing out a whole essay or writing out 7-mark short answer questions compared to, just sort of reading the options and then picking one. We've then got 15 marks of short answer, which is coming straight from the human rights section. So just making sure that you are practicing human rights, and obviously these two are core, so everybody would be doing that. Everyone who's doing legal studies would have studied these. So just making sure you're practicing that, and again, there are many past papers on the NESA website for you to access. So if you feel like you are not that confident with a certain section, would definitely recommend practicing in that with the different papers. And obviously just remember that you practice from the papers where the current syllabus has been assessed. After that, we've got the crime essay, which is another 15 marks. So your crime essay is going to be 15 marks. It's going to not be as long as your other option essays. So your other option essays are 25 marks each, and so the two options there, so this is all core, so every student will be studying crime and human rights. So the 20 multiple choice, the 15 marks of short answer, and the 15 marks of the crime essay are all core. Every student will do these, and then with options, you're choosing two options. You're choosing from the two options for each topic. So whichever topic you've covered in class, you would write an essay for. So these are 25 marks each. So just something to highlight is that this is literally 50% of the paper. Right, so you have 100 marks and 50 of the marks are coming just from the two options. So really, really important to make sure that you have a really good understanding of the option essays, and then also focusing on the rest of it as well. So yeah, something to keep in mind there. Okay, then moving on to your multiple choice section. So this should be the main place that you should be boosting your marks. So read every single word of the question. It is so, so important because at the end of the day, you have a 1 in 4 chance of getting it right. So just make sure that you are sort of thinking of it and you do have the mindset that this is the place that I can boost my marks, and that every single word of the question is read, because sometimes they can trick you with that. Don't spend too long on one specific question, so mark it with your pen and move on if you feel like, oh, well, I don't really get this, so I don't really understand what this is asking me. Don't get stuck on it, just mark it and move on. And if at the end of the day, the end of the exam rather, you come back to it and you still can't figure it out, just have a guess. Never leave a multiple choice question blank, or any question regardless. Eliminate the distractor and the other one. So you should be left with 2 similar answers in which you must choose the most appropriate answer, because sometimes it can feel like they're both correct, but it's important to know that that's what they want you to think. So choose the most appropriate answer based on your knowledge and your understanding of the content. So making sure you are doing as much practice as you can, because the questions that come up are quite similar to the ones that have come up before. So if you do understand those and if you practice them enough, then it will become second nature to you when you get to your exam to have a look and be able to tick off the right options. So definitely something to keep in mind there. Next up, do not spend the recommended time of 30 minutes. This is something that, again, every student differs, but I would suggest to try and see if you can do it in a shorter amount of time, because 30 minutes, personally, and from what I've heard from other students, is a lot of time to be spending on the multiple choice. So try to do it in a shorter period of time and see your accuracy rate as well. If that's something that ends up working for you, would highly recommend to try and cut down the time there, and then you can dedicate that time to other sections where you feel like you need more time. Prioritize the areas you are getting wrong for revision, right? So for example, you may have gotten your trial back and you realize, well, I'm not really good at police powers. I don't know what they are, I don't know what they consist of, and I don't know what to talk about or how to analyze them. Go back and really revise them and prioritize those areas rather than areas that you already feel comfortable with. So I would suggest to make some sort of a list of high priority areas versus medium versus low priority areas, because you really want to focus on the areas where you feel like you're not getting the highest marks and you feel like you're not understanding everything, because you do have the opportunity now to ask your questions, ask your teachers, ask your tutors all the relevant questions that you have, and then be able to make notes and things like that with that. So you can do this via the aid of your syllabus. So literally print out your syllabus or have your syllabus online and like highlight everything that you don't feel comfortable with, and then prioritize those in accordance to what you feel like you struggle with the most. Right? So you can do that via your syllabus, you can do that via your past assessments and exams as well, where you feel like you haven't gotten enough marks or you feel like you haven't been able to excel in those areas. Those are the areas that you want to focus on. And the same thing for the sections as well. So if you feel like I'm not good at the short answer for human rights, I feel like I'm good at multiple choice and I'm fairly good at the essays, but I really need to focus on the short answer. And then you'll know, like, okay, let me print out all the past papers and just attempt a bunch of short answer and see how I go with that. And finally, just practice, practice, and practice. That is the key to success in this course, is to just keep practicing, especially multiple choice. Very, very easy to practice. NESA actually has a resource available of multiple choice quizzes that you can also attempt. So please do have a look at that if you're interested, and sort of collect the papers and then have them marked at the end as well. So that's something to keep in mind. And then also you can just do it, like print out a paper. I think that's the best way to do it, is to print out a paper, turn on a timer and have a go and replicate those exam conditions, put yourself in those exam conditions, so that on the day you don't feel nervous, you don't feel panicked when you are in those exam conditions, because sometimes that can panic students because they're not used to being in exam conditions. But if you are so used to doing it anyway, like being on your own, being in a room with just you, just the timer and just pen and paper, and you're just attempting it, it will really, really help boost your confidence. And hopefully when you get to the stage of your final exams, or your HSC exams, you will find that it's second nature to you and you'll become a lot more confident with that. So those are some tips for the multiple choice. Again, a bit of a summary. Read the questions carefully. Sometimes they're designed to trick you, and also read every option, every answer, right? And then what I would do is I would cross out the incorrect answers, or if there's specific parts of the answer that are incorrect, you can also cross those out. So this will just help your brain sort of understand, okay, well, I definitely know it's not B or a C, so I know it's going to either be A or D. Now, which one do I feel like is most correct from my understanding and knowledge? Well, I know that A seems like the most correct because I remember studying it. So there you go, the answer is A. Underline, highlight. So underline, highlight, make notes, whatever you feel like is necessary for you to accurately understand the question or assess your options before choosing the correct one. Do it. It's so, so important that you do that, because it will help you out tremendously in terms of understanding the content and also understanding what sorts of options are available and which one you feel like is the most correct answer or the most appropriate answer. So yeah, something to just keep in mind. Make sure you read the questions carefully. Make sure you read every single answer. Make sure that you cross out the incorrect answers or the incorrect parts of the answer, and underline or highlight, make notes, whatever you feel like works for you to help you out. And then moving on to short answer. So we're looking at short answer, which is going to be human rights. So look at the directive term. So is it analyze? Is it assess? Is it describe? What is it? Right, be able to understand what each one means. So for example, if it's describe, then you're looking at the characteristics and the features of a certain thing. Okay? If it is explain, we know that it's cause and effect, for example, right? So it's really important to be able to look at the directive term and then be able to understand what it's actually asking you to do. Okay, so next up you want to look at the mark allocation, as this will give you an indication on how much you should be writing. So if it is a 6-mark question, please don't write 2 lines, and if it is a 2-mark question, don't write 10 lines. It doesn't make sense, right? And a really good way to understand how much you should be writing is to look at the lines that you're given to write. The lines are a guideline of how much you should be writing, so as long as you stick by that, you'll be fine, right? So they have done that. They have given you the lines for that exact reason. So just be able to understand in your mind how the marks are allocated as well. So when you do enough practice, you'll find that that will become something that you will inherit and you'll just think about automatically if you do enough practice. So if it's a 3-marker, you say, oh, I know that 1 mark I'm going to get for stating this, I'm going to get another mark for defining this, or whatever it is. Right, so just be able to look at mark allocation. I think now is a good time to start practicing that. So when you get to your HSC, it will come to you quite naturally to do that and have that process in mind. Next up is to look at what part of the human rights syllabus it comes from. This is where your syllabus, again, becomes very important. Like I've been stating throughout the lecture, always look at your syllabus, always look at where it's coming from, because as soon as you understand which part of the syllabus is coming from, you'll remember the content that you've learned, you'll remember the revision questions you did, and then you'll be able to answer the question more effectively. So that's why I would always say when you're studying, always have the syllabus out in front of you, always be highlighting, checking things off that you feel comfortable with, that you don't feel comfortable with, etc. Try and smash this section out in about 20 to 25 minutes. Again, to leave more space for your essays, which are a significant chunk of your marks for the HSC exam. So just really try and work through that, because the more that you're able, or the more confident that you feel in trying to complete that, the less time you'll feel like you need to complete that, whilst also achieving a high level of accuracy. So the only way you can really do that is to practice. Again, put yourself in those exam conditions, set up a timer, have a pen and paper ready to go, and just attempt a bunch of past papers. But after attempting them, please do make sure that you look at the marking guidelines and you're able to answer to the marking guidelines, and you're able to mark and see how many marks you're giving yourself. So if you feel like, oh, I've actually missed out on a couple of things, note those things down, so next time you know exactly what you need to write and how to improve. Simply doing the paper but not marking it or checking whether your answers are correct or incorrect is just a waste of time, because you don't actually get any feedback or any response. Make sure that you are backing up your responses with contemporary legislation, cases, media, international instruments, and documents. Really important, right? It's such an important part of the course, is to look at the legislation, cases, media, etc. So we have gone through a lot of them today, so you can definitely utilize the ones we've gone through today, as well as the ones that you would have gone through in class or from your textbook or from your notes. So I would highly recommend them. And also if you are interested, you feel like you need a little bit of assistance with that, the Legal Studies Study Guide also is a great way for you to be able to get all of those LCMID in there as well. So always answer what the question is actually asking of you. Do not fluff. I think this is something that is quite important, especially if it's like a 4-marker. If you're spending half of that time just writing extra stuff that's not helping you answer the question, then you're probably not going to get the 4 marks, because half of it doesn't really add anything or add any value. You want to be direct with short answer. You want to just answer the question. I know in essay sometimes you can add a little bit more and get away with it. That's fine. And again, sometimes it's actually good to add a little bit of extra information. It's actually going to be appreciated. But in the short answer, it's not, because you just want to directly answer the question and move on to the next one. And you'll see that the questions are more direct. They're just asking you to simply, whatever it is, explain something, describe something, assess something. Just do as what the question's asking you to do, and then you can move on to the next one. Make sure you plan your answer before writing. As you're practicing now, you may feel like you need to have a pen and paper to plan, or jot some things down, or actually write out like a proper plan. That's fine. Try and do it as much as you can now, and then try to practice doing it without jotting down a bunch of things, and just jotting down a few things if necessary. So you want to get to a stage where you're jotting down a few things, and then the rest of the plan's in your brain, and then you just can like sort of regurgitate that back onto your answer. So, I guess when you're starting out, you can sort of have like a mini structure, like plan, which is completely fine. But when you get to exams, don't waste too much time on your plan, but I would still recommend having a plan. So those are some of my tips for the short answer section. So again, look at directive term. If you feel like you're stuck on a certain directive term, have a look at past papers for examples of that directive term, the types of questions that you asked with that directive term, and then the marking guidelines. Also, please have a look at the NESA website, because they have a glossary of all of the directive verbs. And then look at the mark allocation and the lines that you're going to be given. Look at which part of the syllabus it's coming from. Make sure you're checking things off, highlighting things. Look at the timing, so try and practice as much as you can now. Have contemporary LCMID. Always answer what the question's asking of you, so be direct with your answer and plan your answer before you write. So yeah, there you go. Look at the directive term, look at what part of this human rights syllabus it's coming from, look at the mark allocation, and finally look at how much you need to write. So normally it's 1 mark is equal to 3 lines. Okay, so with reference to one human rights violation, outline the role of a non-legal measure in responding to this issue. So this is a 3-marked practice question. So I've got a little bit of a plan or outline of what you should be doing if you get a question like this, for example. So first of all, you want to be able to break down the question. So we know that it's asking with reference to one human rights violation. So one human rights violation, and then you want to outline the role of a non-legal measure and in responding to the issue. So our verb, it's the first thing we're going to look at, it's outline. Right, so what does outline mean? You're looking at sketching in general terms or giving a brief description. So you're not going into too much detail really with it. And you can see that again, it's 3 marks. You're not going to go into heaps of detail. Then the second thing that you want to be able to do is to define the human rights issue that you are going to talk about, because it's asking you to have one specific violation that you're referencing. So have that in mind, right? So we know that we're outlining, we know that we're going to define the specific issue that we're focusing on, and then we know that the certain part they're asking, again, is for a non-legal measure in response. So identify a non-legal measure. It can be media, it can be NGOs, and explain what they do. So what does the media do? They raise awareness, etc. And they, I guess, encourage government action in that regard. And then number 4 is to clearly describe and explain how this non-legal measure responds to issues. So you're putting the two together. So outline is just the verb. This is the first part of the question, the second part of the question, and then putting the two together. Okay, so hopefully that is clear. I would suggest that you pause here and just have a go at answering this question, and see how you go in terms of following the structure and if you find it to be helpful. And so this is something that you can also do when you are practicing in your own time. So here is the response. So here's a sample answer that you can have. So again, we're looking at one human rights violation. We're outlining, so sketching in general terms, the role of a non-legal measure. So for example, we're looking at slavery specifically. So we're going to start off with what slavery is. So slavery is the breach of a human right where a person is believed to be under the total control of another person and considered to be their legal property. So the first sentence, again, it's just defining exactly what slavery is. We then move on to slavery breaches both the UDHR and the International Covenant on Civil and Political Rights, 1966. So it's saying exactly how this is a violation. right? For example, and they've actually got the relevant documents there as well. So that's also going to add on marks, because, or it's going to show the marker that this person knows what they're talking about and they've got that contemporary LCMID. And then they go into an example. So for example, the right to life and the right to freedom from slavery. So then they go into the non-legal measure part. So one non-legal measure used to respond to this issue is media and non-governmental organisations such as Amnesty International and Anti-Slavery Australia. So we've literally got examples again to show the marker that we know what we're talking about, and we've got the relevant examples to back up what we're saying. These NGOs, basically, how do they help how do they help respond to the issue? Well, these NGOs raise awareness and promote breaches of human rights, so legal organizations can take action to further prevent this from happening. So, by exposing these human rights violations, society is made aware of slavery occurring in modern times, right? So you can really see how it's all tied together at the end, because you're putting the two together, the human rights violation and the non-legal measure. So again, starting off with the definition of the human rights violation. How is it, or why is it a human rights violation? What is the non-legal measure to respond to this? And then how can you put the two together? How does it actually respond to the issue? So there we go. We start off with the definition and identification of a human rights violation, how it's a human rights violation. We then look at the non-legal measure. So the non-legal measure of media and NGOs, and we've given two examples of the Amnesty International and the Anti-Slavery Australia. And then we go to explanation of the non-legal measure and how they both sort of combine together. So these NGOs raise awareness and promote breaches of human rights, so legal organizations can take action to further prevent this from happening. By exposing these human rights violations, society is made aware of slavery occurring in modern times. Okay, moving on to the crime essay. So again, with the crime essay, I would say have 45 minutes on this essay max. Again, try to work out what works best for you. And that means looking at how much you think would be good for the recommended time for you personally. So have a time that you want to set to complete each section by. But don't spend too much time on this essay, because it's 15 marks compared to your other two options essays, which are 25 marks each. So don't spend more time on the crime essay, for example, than your options essays, because their options are worth a lot more marks. So then you want to use contemporary LCMID from the last 5 years. So again, there are many LCMID that you can find in your notes with your teachers, from like notes from ATAR notes as well. So like, again, up to you how you decide to do it. You can also do a lot of research, like you can find a lot of stuff online. If you just do enough Googling, you'll find a lot of media articles, a lot of cases that you may find interesting and you would like to incorporate. So do have contemporary LCMID. You can even have a separate notes page, or like separate notes for LCMID specifically. Make sure that you revise niche areas of the syllabus, such as themes and challenges as well as student learn tos. So niche areas, themes and challenges, and student learn tos are very, very important, because they are where a lot of the questions are coming from, and all of the questions are coming from the syllabus. So that's something important to note as well. So their syllabus should be, so the syllabus should be a very important thing that you're focusing on and you're always looking at. Next up is to make sure that you have a clear structure, right? So have an introduction, have your body paragraphs, and have your conclusion, right? Have that structure set, because essentially it will help you out in terms of one of the points, which is to have a sustained, logical, and cohesive response. And this is throughout both your crime essays as well as your options essays for the two options that you're going to be doing. Right, so plan the way that you're going to write the essay. So what method will you use? It's completely up to you. You can do like cases, you can do different topics, or different subtopics. You can have it in terms of a lot of different ways. So it's up to you really which method you use to write it. And I think for some people, it also depends on the type of question that you get, but that's something to keep in mind. Remember, this essay should be 600 to 800 words, which is also known as about 4 to 6 pages. So again, keeping that in mind when you're going through it and when you are practicing. But remember that this is 15 marks, so it's not the heaviest part of the exam. It's not the one that carries the most weight. It is the options that do. So like for example, one options essay is literally 25 marks, so that's a significant chunk of the exam. And do not get stressed if the question is difficult. Think outside the box. Try to remember that everything that they're assessing you on comes from the syllabus, so that, you know, even if you feel like at first, like, I've never seen this before, if you've gone through the syllabus enough times, which is why I recommend that you do that, like go through the niche areas, go through themes and challenges, go through student learn too, so that any curveball they throw at you, you will be prepared for it and you'll say, I know how to do this. So if you ever feel like, oh, I don't really know this, I haven't seen it before, you definitely have if you've gone through the syllabus, because they can't really examine you on anything outside the syllabus. Option essays. So for your option essays, you've got 45 to 55 minutes on each of the essays. This is probably the most important as it makes up 50% of your overall mark. Again, these also, I would say, like the 45 minutes, the 45 to 55 minutes, they are recommended times. Like, you can like shift it according to what you feel like works for you personally. But I think these are a little bit more effective than what sometimes a NESA exam paper says. So contemporary LCMID, again, from the last 5 years. Make sure you do this for your options. Again, it's very important because a significant chunk of your marks are coming from here. So you want to have the stats that work with it as well, or the LCMID as well that work with it, so that you are giving yourself the best opportunity to get the highest mark that you possibly can. Make sure that you revise the themes and challenges specifically. Right, so make sure that you're looking at the themes and challenges and you've got them down, right? So because if you don't have them, chances are, you know, you are going to potentially be missing out on marks, because a lot of the times the themes and challenges are where the questions are coming from. So if you don't understand them, it can be a bit of an issue. So make sure that you do have that in mind as you run through it. Next up, play to your strengths. So will you choose the general or the specific question? It's up to you, whatever works best for you. That's why I would suggest practicing as many questions as you can. Even if you don't want to write whole essays every time you do a practice, you can sometimes choose to write whole essays, and other times you can just write essay plans, because they work just as well. As long as you do have enough practice with writing whole essays so that you're not stumped on the day. But if you feel like, I've written enough practice essays today, I don't want to write an entire essay, but I do want to get a bit of practice in, I'll just write a practice essay plan. So what would I write in my intro? What LCMID would I include? What would be my conclusion, again, for that specific question, and do the same thing for each paragraph. Right, so in that way you'll realize, actually, I really like answering the more general questions, or actually I really enjoy answering the more specific questions because I have a lot more to say. So when you see the question, you'll know which one you feel like you want to opt for, hopefully, if you've done enough practice, and you'll know, okay, I actually have a lot more case studies and a lot more legislation and media for this question, so I'm going to choose this question. So again, just make sure you do enough practice so that you're not stumped on the day and you're like, I actually don't know which one to choose, and you're wasting time trying to decide. So try not to make that happen, and try to sort of be prepared prior. Make sure you have a clear structure. So have the introductions, the body paragraphs, and the conclusion. Again, really, really important to have a sustained, logical, and cohesive response. That's something that the markers are going to be assessing you on. And even just the idea of it being sustained is really important, because if it's not sustained, it can actually make you lose marks. So that's something to have a look at in the marking guidelines if you haven't already, is that for the top band you have sustained, logical, and cohesive. A band below, it says you've just got a logical and cohesive, but it's not sustained. So making sure you're looking at little things like that now's the time. Do the practice, get in the mind of the marker so you know what the marker exactly wants, and so you can replicate what the marker would like. And so when you are doing the exam, you can replicate that and then hopefully give yourself the best opportunity to get the highest mark. Plan the way that you are going to write the essay. So what method will you use? Again, it can differ from the crime method that you use. It can differ from essay to essay depending on the question, but just have a think about it and have, you know, the different methods up your sleeve so you know exactly which one you're going to go for depending on the type of question that you're asked and depending on your knowledge and your understanding of it and the cases that you know for it, legislation, etc. And remember that this essay should be 800 to 1,000 words, so around 6 to 8 pages. Okay, so again, something to really keep in mind is that this one is significantly more than this one. Right, so you can see that, and again, it's 10 extra marks that's given for your options essay compared to a crime essay, so factor that in, so 6 to 8 pages as well. So again, just a summary of both the essays. So for the crime essay, about 45 minutes. Again, figure out which one works, what timings work best for you for each section. Contemporary LCMID. Remember, just a sec, I guess I'll go back and just mention that. Look at the timing, what works best for you, but also look at what works best for you in terms of accuracy, in terms of how much time you're spending versus accuracy. So if you're spending a lot more time but you're getting a higher accuracy, try and cut that down to a certain amount of time. But if you feel like at a certain point it's actually affecting your accuracy, then have a think about how you can improve that. So use contemporary LCMID from the last 5 years, focus on niche areas of the syllabus, so themes and challenges student learn twos, have a clear structure, plan out how you're going to write the essay, looking at which method you're going to use, look at the amount of words and pages that you need to be writing, and always remember that if the question is difficult, it's not too difficult. If you've gone through the syllabus enough times, please go through the syllabus. And for the options essays, 40 to 45 minutes, 45 to 55 minutes. Again, look at what works best for you. Contemporary LCMID, last 5 years. Make sure you're revising the themes and challenges. Make sure you're playing to your strengths. Looking at general, specific, which one works best for you. Have a clear structure. Plan out the way you're going to write your essay. And remember that your essay should be 800 to 1,000 words. Okay. So essay introduction doesn't need to be fancy, it just needs to be clear, right? Make sure that you understand that, right? It doesn't need to be really, really fancy. They are not worried, the markers are not worried about how fancy it is. They just want to know, do you have have you been able to answer, first of all, to directive? Are you clear in what you're trying to say? You don't have to make your entire judgment in one sentence. You can split it apart. It's okay. Your opinion really matters. So it's one thing to know the content, and it's a good thing to know the content, but if you're just vomiting out or brain dumping the content onto the paper and you're not adding your own opinion or your own assessment or your own judgment, you will definitely lose marks, because most of the directives in essays require you to have an opinion. So it might be to a certain extent, to a great extent, to a limited extent, something, or assess the value of blah, blah, blah. So you need to have an opinion, and that is something important to mention in the introduction of an essay. Next up, establish your opinion. So is it yes, no, a little, a lot? What is it? It's up to you. Don't limit yourself early. So yeah, just give yourself the best opportunity for success. And so make sure that you've got that in your intro as well. And also just try to do as much practice as you can now so that you can feel like it's a lot easier when you get to your exam. There's no point marking your thesis there's no point making your thesis more sophisticated than your essay. So just make sure that you're keeping that in mind. Like literally there is no point in doing that, because again, the essay is forming the basis for your entire response. So don't make it so difficult for yourself, right? So it doesn't have to be overly complicated, doesn't have to be really difficult to understand or very fancy. You just want to get across your point in a well enough way. Great. So with our body paragraphs, we've got a few different methods. So this is what I was talking about earlier when I was talking about which method you'll use. So you've got method 1, which is your legal and non-legal responses. So you can do 2 paragraphs, for example, on legal and 2 paragraphs on non-legal, or and then you've got 3 integrated paragraphs, which is more sophisticated. Again, up to you which way you want to do it. But this is good for questions that specifically do ask for not legal, non-legal. That's a great way to go about it. Second way you can go is by cases. So you can have specific cases that you're referring to in each paragraph. And then you're sort of basing off content around that as well. And then method 3 is by affected groups. So like normally when you're asked about offenders, victims, society, how their rights are balanced, you can have 1 paragraph looking at offenders, 2nd victims, 3rd society, and then making sure you're concluding at what that balance is like and having your own judgment with that as well. So these are some different methods. There can be other methods that you can use as well, completely up to you. There's no set structure on the way to do this, and it's very much dependent on what you like. Remember that, you know, somebody who does it by cases and somebody who does it by affected group can still end up with the same mark. Like, it's not like there's a specific right way to do it. Method 4, theme or topic in the criminal justice system. So whatever it is, again, looking at the syllabus will really help you out with that as well. So again, a bit of a summary. Method 1, you can talk about legal, non-legal responses. By cases is method 2. Method 3 is by the affected group, and method 4 is by theme or topic in the criminal justice system. And then your conclusion. So this needs to be straight and short and straight to the point. So really, really important to remember that because you don't want to spend too much time waffling in your conclusion. You just want to sort of conclude it off. Don't introduce any new points, like don't bring a concept out of nowhere. That's not really helpful because you're just recounting what you've already talked about, but you don't need to recount everything as well, which we'll talk about. 3 to 4 sentences max, again, quite short and straight to the point. Includes a summary of the dot points that you've discussed, but you don't need to recount every single point, and especially not in a lot of detail. Just recount briefly what you've talked about, and addresses the question by looking again at your argument or thesis. So you can just quickly mention it in a few points and then end off by, like, again, mentioning what your argument or thesis is. So to a certain extent, to a great extent, to a limited extent, whatever it is. Right, so again, something to keep in mind. So now until the exam, what do you want to do? You please go through as many past papers as you can. Like, go through the past HSC papers, look at what the questions are like, practice them as much as possible, because sometimes the questions that come up are quite similar to the ones that have already been assessed in prior years. So you'll get that experience, you'll get that practice, and do it under timed conditions. You don't have to do the entire paper in one go. You can do different sections every day, right? Or you can do one section every couple of days, because I do understand you obviously have other subjects that you want to work for as well. Cram your notes into a few pages. So this is really helpful for, you know, revision time when you've got everything but you just want, you know, the main points, or like the night before the exam, and I don't recommend cramming the night before the exam, but if you have certain concepts that you don't know, focus on those. So make a little like list of things that you don't know, like, and then make a little cheat sheet essentially and practice that before your exam so that you feel like you're more comfortable with it, because you've got the main points on there. And so hopefully by then you will feel comfortable with it in the exam. So do essay plans and not practice essays. Again, practice essays are good if you haven't done any, or you feel like you don't have enough practice in structuring it out and making sure it's logical, cohesive, sustained, whatever it is. But do essay plans because they're really, really important, right? They are essential to success, and they can, I guess, cut the time that you're spending revising as well. Make multiple choice your biggest strength because it's the, I guess, easiest way to get marks, right? Because you're not really writing anything, you're just choosing an option. So that's something to keep in mind. Plan how you're going to approach the exam, whichever method works best for you. and sleep and eat well, right? So just make sure that you're giving yourself enough rest time and you're taking breaks as well, because it can be quite an overwhelming process and you don't want to burn out at this stage. And go through your syllabus. Please, please, please go through your syllabus, because that is where the questions are coming from. So again, go through past papers, cram your notes into a few pages. Again, especially on the last few days when you're just prepping for the exam, like create a little summary or cheat sheet, as people like to call it, or summary notes of like just a couple of pages or a page of just the content that you don't know, and just keep practicing that. So then hopefully once you've gone through that enough times before the HSC exam, you'll feel comfortable with those topics that you didn't feel comfortable with prior. Do essay plans, make multiple choice your biggest strength, plan it, plan, and take rests, as well as go through the syllabus. Okay, moving on. Okay, everyone, so I just thought to finish off today's lecture, I thought I could just pull up the 2020 Legal Studies HSC paper to just show you the different sections, what they consist of, and then go from there. So you've got reading time of 5 minutes and then working time of 3 hours. So something important to note is that you've got the different sections. Now, I've given you what I think are good recommended times for each section, but you have got this in case you feel like you don't really you want to try and figure out your own way. So you've got the recommended times for the multiple choice, which is 30 minutes, for section 2, which is your crime essay, which is 15 marks, and your short answer for human rights, you've got 15 marks as well. So they're giving you about an hour in total for that. And then 50 marks, which is your section 3, your 2 option essays, you've got about an hour and 30 minutes. So there you go. Those are the recommended times. And then you've got your multiple choice, your human rights responses to go through. And then for the essays, there was also something that I just wanted to flag to help you all out. So essentially we've got a few different points that are going to be assessed. So when you're going through the essays, just make sure you're ticking these off and make sure that you're achieving all these points. And if you feel like you're not achieving a certain point, try and figure out how you can achieve it, because you're going to be assessed and marked in accordance to this. The first one is to demonstrate knowledge and understanding of legal issues relevant to the question. So make sure you know which legal issues are relevant. Make sure you know how to break them apart, talk about them, and show the marker that you know what you're talking about, essentially. Communicate using relevant legal terminology and concepts. So look at the glossary in your textbooks. They will provide you a list of all the legal terminology that you can be talking about. Refer to examples such as legislation, cases, media, international instruments and documents, so your LCMID. Please do refer to this. This is so important. If you don't, you're definitely going to lose marks. So make sure you have relevant legislation, cases, media. In the crime essay, you're not given an option, but in the option essays, you are given an option. So you can definitely choose the one that you feel like you can talk more about and you can meet these points better with. And finally, present a sustained, logical and cohesive response. Really, really important to practice this. This is one thing that the essay plans don't allow you to do or allow you to practice. So I would suggest don't completely substitute your essay writing with just essay plans. Do write essays if you feel like you're not confident enough with this point, and do practice essays anyway, but also you can do essay plans if you feel like I just want to practice it a little bit, but I don't want to give up 45 minutes to an hour to just write an essay. So that's that. And then again, with your options, you've got the same ones: demonstrate knowledge and understanding of legal issues, relevant terminology, legal terminology and concepts, refer to relevant examples, legislation, cases, media, international instruments, documents, present a sustained, logical and cohesive response. And then make sure that you look at the questions and make sure you look at choosing the one that works best for you. And that basically concludes the sort of summary of basically what the exam consists of and some general tips for you there. So I'll just head back now. Okay, so that essentially does conclude today's lecture for the HSC revision for legal studies. I'd just like to say a huge thank you to everybody for listening in today, and I hope that you found this lecture somewhat useful and that you took something away from this lecture that you'll utilise in your revision for your legal studies exam. So thank you so much, and if you haven't already, go ahead and have a look and see if you would like to register for some of the other lectures that we've got going on. But other than that, thank you all, and yeah.